It is Tuesday, June the 11th, 2019, and here we have reached week 6 in Introduction to Criminal Law. As I told you before, and I said to many of you that the quarter was going to go fast, and before you know it, that we get week 6, and here we are. And that you should be aware of the fact that the quarter is ending Friday, this Friday the 14th. So I'm going to share my screen. Here we are right here. And you can see the information that you've been seeing the whole quarter. And you see, too, that we have reached week 6. So you see week 1, open house, 2, 3, 4, 5, and at the end of the lecture 6 will be there. So let's take time to look at our announcements. Reminder, each of you will take the time to complete the course evaluation. It was sent to your email, so you'll want to make sure you do that. So for this week, we're going to discuss defenses to criminal liability. And Chapter 10 of the text, A Brief Introduction to Criminal Law, is the place you get your information. I also previously sent you the PowerPoints that coincide with Chapter 10. And then you need to go over the activities, mental disorder, insanity defense, which we'll talk about, involuntary intoxication, mistake of fact, mistake of law, and self-defense. Then you'll look at some of the key terms for practice, mistake of law, of fact, and then your practice quiz. Now, the practice quiz is to prepare you for the final exam, which is really the quiz that's due on Friday. So let's take a look at our assignments. Discussion assignment, murder or self-defense. The initial post is due tonight, June the 11th by 11:59 p.m. Central Standard Time. And the reply post due 11:59 p.m. Central Standard Time, but you know when that is. That is actually Friday. Okay? So the deadlines are in the course calendar for the initial post and reply post. Finally, complete the written assignment, the quiz, and this time, that's what I was talking about, which is basically your final exam, which covers 5 and 6 material, and that's due Friday, June 14th. And then there's a reminder that the quarter officially ends Friday. Friday, not Saturday, not Sunday. And then reminds you to take the student evaluations. Let's go and look at the calendar, which I've referred to constantly throughout this course. And you can see where we are here. We are right here. And you see your reading assignment that was due on yesterday, your initial post, and then your lecture. And then Friday the 14th, your reply post is due, your written assignment. Now, what is your written assignment? This is it. The quiz. That's it. That's all you have for this week to do. But again, remember that you are not going to get any points after the 14th. And then this reminds you the due dates. The quiz, due date, and then the live classroom keyword that I'm going to give you will be due on this Friday, the 14th. So that's it. So you want to make sure that you have all of these assignments in and complete it on time in order to receive credit. If it is 1 minute after 11:59, which is 12 o'clock, which is the 15th, you won't get points for it at all. So be aware of that. So don't tell me something happened with your computer or your system. I need to make you aware of the fact of what the school rules are. And the school rule says that the course ends at 11:59 p.m. Central Standard Time on the 14th, and that's what I will abide by when it comes to submitting your final grades. Okay, so let's go down and let's close the tools out, and then let's go into Module 6. See, you'll see the assignments. There are no rubrics this week except for the discussions, which you know what that standard rubric is. And then there's the quiz, a time exam set for 30 minutes. And then you know that you're supposed to abide by the academic misconduct policy. That means that you're not supposed to have any notes, books, papers, or anything out when you do take that quiz and in your live classroom lecture. And those are the assignments for this week. And then let's go to the course content. So the topic, defenses to criminal liability, and we're going to explain self-defense and defense of others, deal with mistake of law and mistake of fact, excuse defenses to criminal liability, and then we're going to close dealing with deadly force, or self-defense goes in there. So we're going to start out with mental disorders, which is the insanity defense, involuntary intoxication, mistake of fact, and then self-defense. You can then you know about the key terms and the mistake of law or mistake of fact, and then the quiz. That's practice for the real deal, which is the quiz down here, which is 30 minutes. All right. So let's look at what we talk about. The law presumes that everybody is sane, and that when a person commits a crime, and the person that commits the crime is found guilty beyond a reasonable doubt. As you know, that's our standard. If you don't know this by now, then I don't know where you've been. But there are instances where we have what we call affirmative defenses, justification defenses, excuse defenses. And so affirmative defenses basically apply to situations where individuals don't say that they didn't do the offense, but what they say is because of the fact that there was some legal reason why they shouldn't be held accountable or responsible for it. And starting with the mental disorder, the insanity defense. And so people that are convicted of crimes, there's mens rea, you be aware of that, which has to do with the mental state of the individual at the time, such as premeditation, knowing, or intent. If you pay attention to those, premeditation, knowing, or intent, they all address the state of mind of an individual at the time that an offense occurs. And you're found guilty if you do something in a premeditated fashion, if you do it knowingly, that is, with knowledge, with the ability to be able to recognize basic right from wrong, and or knowingly, in other words, you just totally act in total disregard of the law, or either whatever it is that you did. And so if you are committing these acts, you're going to be guilty. However, you can say, yes, I killed that person. Yes, I did this. But at the time that I did that, my mental capacity was not present for me to be held responsible for the crime that I committed. And so by doing that, what you're saying is that I did it, you're admitting you did it, but you're saying I didn't have the legal capacity to be held accountable for the acts. So now, says that the defense may be raised, but most of the time you're going to find out that dealing with particularly the mental disorder or insanity defense, it's not going to be very successful. I can tell you that I had many cases that I represented individuals during the years that I practiced law as a criminal defense lawyer from 78 to 2000, and even before that, when I worked with lawyers and witnessed and observed courtrooms, very rarely did I see an individual be found not guilty based on the justifiable affirmative defense of insanity, because the individuals who commit these issues, they actually find themselves with a difficult burden. So of the affirmative defenses, the first one we're going to deal with is insanity. And there are various tests that come about. And what happens is that individuals are subjected to, first of all, examinations by a psychiatrist to determine whether or not at the time the offense occurred that that individual lacked capacity to commit the crime. The verdict that's given when a person, or finding from a judge, is that when a person is insane, the verdict says, or judgment is not guilty by reason of insanity. And now be aware, though, just because a person is found not guilty by reason of insanity doesn't mean that they walk out the same way as if a person was found not guilty of committing a crime. But in the insanity instance, what happens is that individual is then going to be committed to a facility, mental hospital, to be treated. And once that person is committed, they're not going to be released until such time that a doctor determines that the person is competent and safe to be released. Now, that doesn't happen very often. There was a young man by the name of John, I think his name was Michael Hinckley, but I know it's John Hinckley, H-I-N-C-K-L-E-Y. John Hinckley was guilty of attempting to kill the President of the United States, and Ronald Reagan. And he was not successful in killing the president, but what happened is that he did seriously wound the assistant, Brady, and he also wounded a Secret Service officer by the name of McCarthy, who was, I think he still is, the chief of the police department in Illinois in a town called Orland Park. And so what happens is that person was held until just recently, when it was determined that he's released. I think he's free now at this particular point. But very rarely does it happen. And I'm going to talk in a few minutes about the various standards that take place. So most states, allow the insanity defense, but it is under attack even in those states that do. Again, it's very rarely a successful affirmative defense. So in states like Idaho, Kansas, Montana, and Utah, there is no insanity, but mentally ill verdicts. So they do allow guilty, but mentally ill verdicts. And in those states, the person is deemed and said to be not guilty because of the mental disease or defect. Defendant may then be committed to a treatment hospital until deemed sane. So the point of the matter is that the insanity defense is allowed in most states in the United States, but in Kansas, Idaho, Montana, and Utah, they allow for guilty. The person is found guilty. In other jurisdictions, they're found not guilty by reason of insanity. But that's a terminology that in these 4 states, they're found guilty, but they're determined to be mentally ill, which means still they end up finding themselves in hospitals. Okay? So in the states, if a defendant is determined to be not guilty because of mental disease disorder, that's the insanity defense, then you may be committed to a mental hospital until deemed sane. So there are 3 types of defenses that are available, and we're going to take them one by one, known as the Norton. That's the way you pronounce the M apostrophe N-A-G-H-T-E-N rule. It's called the Norton rule. And then there's going to be the Durham rule, which we're going to talk about, and then the substantial capacity test that was established by what we call the model penal code to try to provide some parity across the country. And so we're going to very briefly talk about these. Now, here's what I want you to focus in on. Listen to the language, and then I'm going to talk to you about the situation. So most courts follow the Norton rule, and it was originally developed in our British system, as much of our law was. And under the Norton rule, a defendant is found not guilty by reason of insanity if and they're going to sound very similar, but there's some differences. If at the time they commit the crime, the mind is so diseased that it prevented the defendant from recognizing that the act was wrong. In other words, the capacity of the mind to function the way it normally should was not present, and therefore the Norton rule applied. We often refer to it in a generic sense as the right-wrong test. So you don't know right from wrong. That's why we call it that. So the example here is that a defendant would have to prove that at the time the murder of a murder, that the defendant thought that they were stabbing someone with a knife that they thought was not a knife, but it was a straw. In their mind, they thought that they were stabbing someone with a knife, that when they were stabbing someone with a knife, they thought they were using a straw. And so what that means is that obviously there's a big difference between a knife and a straw, and there's also a big difference in the damage that a knife and a straw could do. However, the normal mind would be able to recognize that, but the individual who is diseased in the mind would not be able to do that. Or the alternative, at the time of the act or murder, the defendant knew that they were stabbing someone with a knife, listen to me, but by any reason, as a result of the mental condition, they thought there was absolutely nothing wrong with killing the individual. So in other words, they didn't recognize right from wrong in terms of killing an individual. So that's where the Norton rule comes in. It's pretty clear The diseased mind eliminates the capacity of knowing right from wrong. So Florida insanity defense state that all people are presumed to be sane, as I was talking about earlier, and insanity is an affirmative defense if it can be established at the time of the crime that the defendant had a mental infirmity, disease, or defect, which is kind of like what I just talked about a few minutes ago, and that the defect caused the defendant not to be able to know what they were doing or recognizing the consequences as a normal person would. Or the defendant knew that they were doing something, knew what they were doing and its consequences, but the defendant didn't know that what they were doing was wrong. So it's almost like saying the same thing. The key thing is, one, not being aware of the consequences. The other is knowing the consequences, but not being aware that the action that they were doing was wrong. That's the Norton rule, straight and simple. So now that you've got that, let's talk about the Durham rule. Now, the Durham rule is only used in one state and one state alone, and that is New Hampshire. And what it says by the Durham rule is that, and this was established by a case in the United States Supreme Court in 1954, is also known as a product of mental illness test. So that individuals' actions is a product of their illness, all right? So according to the Durham rule, that if a person acts with a mental diseased or defective excuse liability, that's what they're saying. They said, I got this mental problem, or it excuses me from criminal liability. But it has to be to the capacity that it's almost like the right and wrong, but you'll see in a minute that in Durham versus United States, the right-wrong Norton rule was criticized because it said it was just too simple. So in this instance, the mental illness was more complex than a simple right or wrong, and that some actions could be the product of mental illness. So the Durham rule is more liberal. In other words, it's easier to prove. That's why it's not really highly recognized, and stretches the purely intellectual question of this. And the question that is asked is, did the defendant know the difference between right and wrong that is expressed in Norton? So the Durham test stretches the intellectual capacity to the intellectual question. The sole question is, did they know right from wrong? That was expressed in Norton. So if you paid attention to Norton, there had to be actions that were also involved that excused the individual's actions. In the Durham test, it was, did they know the difference between right and wrong, period. So it's kind of confusing to many people, but it was just basically given an easier way to prove insanity. And that's why only New Hampshire is where this came from and where it is. Now, here's where we are pretty much today, dealing with the substantial capacity test, which is the third one. And this is statutory. And the idea of this codification of the insanity defense was to take away Norton, that a defendant didn't know the difference between right and wrong, but rather that as a result of the mental disease, but for the mental disease or because of the mental disease, the person lacked substantial capacity. So they didn't have the capacity because the mental disease blocked the capacity of that individual substantially to either appreciate the wrongfulness or to conform to requirements of law. So in other words, the key thing in this situation is that the person, it sounds almost the same, but there's a big difference in how it operates and how it works. So let me show you by the example. In the state of Wisconsin, it states that a person is not responsible for criminal conduct if at the time such conduct, as a result of mental disease or defect, the person lacks substantial capacity. Notice the word substantial capacity is included in it, either to appreciate the wrongfulness of their act or conduct or conform to their conduct to requirements of law. So it's the key word and phrase in substantial capacity is the name substantial capacity. So you should be aware of the fact that when, as said earlier, that a person is presumed to be sane at the time they commit an offense. So the burden of proof goes to the defendant to prove that they were not sane at the time of the events. And depending upon the state, the burden of proof to be successful with the insanity defense is either a mere preponderance of the evidence, which sounds like a civil action, or clear and convincing evidence. Both fit within that realm. So the point of the matter is that clear and convincing almost sounds like reasonable doubt, but it's a easier standard to prove. So it's not very easy to do it under either of these tests. So the way that it's applied in our jurisdiction in Illinois, we usually use what we call the Amanda Wallace test. That's what some of us use anyway, to describe the capacity of individuals in terms of the insanity defense. Amanda Wallace was a lady who had, this was in the 80s, who had a child that was taken away from her, and the Department of Children and Family Services took custody of that child to protect that child. However, sometime after that, the DCFS reversed themselves and allowed the child to be placed back with Amanda Wallace, the child's mother. I believe it was a boy, but I'm not really sure. I don't recall. But anyway, within a short period of time after Amanda Wallace had that child returned to her, she, I believe, hung that child, but she killed that child. But at the time she killed that child, she was not cognizant that she was in fact killing a person. And so therefore, under the substantial capacity test, she would be considered as sick at that time. Now, let me explain to you what happened with her. I didn't represent her, but I did have the opportunity to see her in the lockup in Cook County Jail, and she was in a corner, and she was rocking side to side and mumbling, and you could tell from the way that she was operating that her mental state was gone. Well, this wasn't the mental state after the offense. This was the mental state she had at the time of the offense that carried over to after that, and she stayed in that capacity. I don't know today if she's still in a mental facility. I think she is, but I can tell you that her mind was so diseased that she definitely didn't recognize that she was killing a human being. So that's an example of what we're talking about. So it's a real hard standard to prove. There are people who try to feign the action. I had a young man who, this young man raped and murdered a young lady who was a meter maid that came to his house to cut on the gas in Chicago. And he had never been in any trouble before. but at the time that she was in the house, she didn't do anything to induce him to do anything, except she bent over, she was wearing pants, to light the pilot, and then he says in the statement that I was able to receive through my discovery motion in the case when I was representing him, that he lost his mind, so to speak, or he lost touch with reality in terms of what was taking place when he first stabbed her multiple times and then kept saying to her, "Are you going to tell?" And she said, "No." And he said, "Yes, you are." And then finally he started stabbing her multiple times. But there was something that he did after that that indicated that he was not of a diseased mind or anything. He began to hide the evidence. He began, so it wasn't that after the fact. So he recognized that it was wrong, what he was doing, and he was using the language and verbiage at that time as well. On the case of like Amanda Wallace, she wasn't doing any of that kind of stuff. She was just carrying out an action that she really thought was different from what it was. She was out of touch with reality. This young man was not out of touch with reality, and typically in those situations, individuals were found to be sane at the time of the offense. Now, when a person wishes to pursue a not guilty by reason of insanity, there is a separate trial. And that trial usually will take place following a motion. And at that time, it is the court who decides whether the person was insane at the time of the crime. And during these hearings, the defense and the state have psychologists or psychiatrists who present evidence as to their opinions or positions of the state of mind of the defendant. And this is how you determine whether or not the defendant is insane or not. But the reports that are provided by doctors. So in the case of the young man that I represented, his mother didn't have the money to hire a private individual, and the only reports that were submitted at the hearing were that of, well, his name was Dr. Reifman, who we knew would probably find him sane at the time of the offense. So that's how that operates. So there is a separate hearing. The judge, or in some cases, a jury, will then, after there's a finding, then the judge or jury may render a decision whether or not defendant was competent or incompetent at the time. If the person is deemed sane, the defendant will be ordered insane, as I said, to a mental health facility until they are deemed to be no longer mentally ill or dangerous. And they usually spend the rest of their lives in those situations. And I was giving you the rare example of John Hinckley. So that's how the self-defense of insanity works. People might think it's easy, but trust me, it is the opposite of that. All right? So now let's talk about involuntary intoxication. So what is intoxication? Intoxication is drugs or alcohol that may impair the individual's capacity to operate, drinking or either taking some kind of drug. And they can claim that at the time they committed the offense, they raised intoxication as a self-defense. Now, remember, it's going to be not voluntary, but involuntary intoxication, not voluntary, involuntary. In other words, a person cannot drink alcohol or become intoxicated and then claim it as a defense. No, it has to be done without their understanding that this took place. Like, for example, somebody slipping a Mickey, something in your drink, or either You know, somebody once asked, what if a person picked up some gin or vodka and drank it, and they thought it was water at the time? I don't think you would get very far with it, because I think that it would be common knowledge, or evidence would be introduced in court, that those two items have a smell that as you drink it and you taste it, that it does not fit uh, uh, water, because water doesn't have a smell of itself. All right. So let's look at two statutes, Michigan and Kansas. First, let's look at Michigan. It says, under the influence of impairment or alcoholic liquor or drug, as defense prohibited exception, definition states that it is an affirmative defense to a specific intent crime. That is a crime for which the burden of proof, and the defendant would then have the burden by a preponderance of the evidence, as you heard earlier, that they voluntarily consumed the legally obtained prescription, medication, or some other substance, and didn't know, or reasonably should have known, that they would become intoxicated or impaired. Now, it's not an easy burden. So it's common knowledge, if you drink alcohol, that you could become impaired. But if someone slips something into your drink that you can't detect, and then it sends you out, then that would be one of the ways of doing that. Sometimes people can argue that they took medication in excess and forgot they had taken it earlier, and then in that case. However, though, there are some statements that could be proven by using the drug, which is a legal drug, that the person, there was a disclosure or a disclaimer on the drug telling them that it may cause impairment. Many people are able to be successfully acquitted in those instances, because sometimes there are individuals who can testify or provide proof that they've taken the medication many times and never had any reaction like that. So, but in the case of someone slipping something or accidentally taking something different, then, or either something they could have eaten and ingested it. So the key thing is done involuntarily, without their knowing it or realizing it until it's too late. The state of Kansas intoxication states that a person charged with a crime was in an intoxicated condition at the time the crime was committed is a defense if, only if, the condition was involuntarily produced and it rendered the person substantially incapable of knowing or understanding the wrongfulness. So basically it puts him almost in a state, almost like a person in a insanity status. So not capable of knowing or understanding the wrongfulness of their conduct, and or failure to follow or satisfy or recognize the requirements of law. So it talks about further, as we conclude this section, that the intoxication defense can be applied in those cases where criminal law was violated that had the requisite elements of intent of a state of mind. For example, didn't know the difference between right and wrong, as I said earlier, and the fact that one involuntarily intoxicated negated their ability to meet the elements of the crime. So that is the key right there. So their state of mind put them in that position. And then involuntary intoxication can happen if a person has their drink spiked. Remember, I talked about that earlier, with an intoxicating substance, or they have an unforeseeable adverse reaction to a lawfully prescribed medication. I talked about that as well. And here's an example of what I'm talking about in the scenario with the Jim. It says Jim, a college student, has been partying all night, but he has to take a test the next day, and he doesn't want to fall asleep in class. So one of his classmates offer him a white pill and tells him it's a caffeine pill, which is an over-the-counter drug, and that it may help him stay alert. However, the classmate lied, and the pill was actually a prescription methamphetamine hydrocodone pill, and Jim had an adverse effect to it, causing him to go into a panic and a rage. So while in his involuntary state, he breaks the window of a store, destroys merchandise, and the police arrest him. So it says if Jim could prove that he was involuntarily intoxicated, he may be found not guilty of the act of vandalism because he was on a trip at the time that was not of his own doing. And that's what I'm talking about when I said involuntary, and I talked about that like somebody slipping you a Mickey or something like that. So that's involuntary intoxication. So now let's talk about mistake of law and mistake of fact. Now, I want to say up front that when we talk about these, we are not talking about committing an act that you should know that's illegal, or that you weren't aware in the jurisdiction that it's illegal, or it's a strict liability offense that you committed, such as statutory rape, or driving under a suspended license, or something like that. But because then there's an old adage that many of you have heard, and that is that ignorance of the law is no excuse. And almost everybody heard that before they even took this course. But let's talk about both of these. First, mistake of fact. It taking place when a person misunderstands something that negates the element, such as the state of Missouri ignorance and mistake states that a person is not relieved of criminal liability for conduct because they engage in a conduct under mistaken belief of fact or law, unless the mistake itself negates the existence of the mental state required by the offense. So that's almost like what we talked about earlier, alcohol or medication or something. Now, under the Missouri law, like other mistake of fact statutes, the defense can be claimed if the mistaken action is related to an element of the law in question. So let's look at this example, which brings it home and makes it clear about mistake of fact. Lisa made a large purchase of goods, and including a mower, and it was a large box, and she puts the box at the bottom of the cart. Now, the top of the cart is filled with items, and she pays for those items. Well, she's distracted by her phone, and she don't pay attention that at the time the clerk rings the item and scans the items, that the clerk, she paid with her debit card, and she leaves the store. Well, she did not notice that the clerk did not scan the mower that was under the bottom. So she stopped by in the parking lot by a loss prevention officer, and they informed her that she didn't pay for the mower. Well, the loss prevention officer calls the police and has requested she be charged with theft. Well, in this case, Lisa would say, wait, hold it. I tried to tell you, officer, that I would have paid for it. I didn't realize that. I didn't notice it. It was a mistake of fact. I thought that every item was paid for. And the intent that she would have established at that time, for the fact that she paid for all the merchandise, that she didn't intend to steal it. In other words, her mental state wasn't to steal, but to pay. But the clerk made the error. So that's a mistake of fact, okay? It is also an example. I've seen it many times at Walmart where people, they have water at the bottom, And we always try to remind the clerk that there's a case of water at the bottom, and to make sure that they do that. And those of you who've shopped at Walmart recently now see that they have a process that if something's not in a bag, that they then will scan and look at it. Years and years, those of you who shopped at Sam's Club, as we did for many years, we don't do it now because we don't get those big bulk items anymore, but that you leave out the clerk, and I don't know how they do it so fast. They'll have a whole basket full of stuff, and they'll look at it, and then they'll draw a yellow line through it, and so forth and so on. The key thing is that it was a mistake of fact. Okay. Another mistake of fact could be in a situation where you grab somebody's bag or purse or coat or something like that, and you take it and you put it on, and then you leave, and then you discover, oh, that wasn't mine. And then you went to try to find the person. That's different. But that person in the meantime tries to argue, no, that you did that on purpose. Well, no, it doesn't fit when a person commits a mistake of fact for them to, under all circumstances, present the situation that it was a mistake or an error. I remember one time I was at someone's house. I used to do closings for title companies, and my coat was hung up in the front closet at the place, and I was getting ready to leave, and they said, well, your coat's in the front. You can take your coat and put it on and leave. I said, okay, and then just closed the door. So I put the coat on, and when I put the coat on, I zipped it up, and I said, okay. Then I went to reach into the pocket for my keys. Instead, there was a lot of money in there. And so I said, oh, wait a minute, this is not my coat. And then one of them came up there and they said, oh, no, that's my coat. But they were the same coat. And so I could have taken the money and put it in my coat or put it in my pocket. And then in that case, then it wasn't a mistake of fact. It was at the time that I decided I would appropriate it to my own as well. Okay, so let's talk about mistake of law. All right, now this is where we get to what I was talking about earlier. It is a defense that can be claimed if a person violated the law, but they thought that their actions were legal. Mistake of law is not the same as ignorance of the law, as I said earlier, because all people are supposed to know the laws that exist where they live. Mistake of law can be applied in the following cases. And these are some examples, and you'll think about it when you hear me go over them. A person relied upon a law that was later found to be unconstitutional. They are not lawyers, and therefore they don't go and they'll take that person and release them because the unconstitutionality negated the law itself. Therefore, it was not a valid law at the time, and therefore it was a mistake of the law because there was reliance upon that law when the prosecution prosecuted an individual. A person acted in good faith, consistent with a court opinion, but they didn't apply it correctly because they weren't lawyers. And so an example of that is if a court says you can do something, like for example, I've seen situations like that where child custody cases or visitation cases, and the person acts in good faith by taking the child, and they take the child and they keep the child for maybe a day or longer, a little longer. But they thought that it was within their period and the opinion wasn't clear on it. And so that would be a mistake of law, and they would have an adequate defense. A person acts upon the advice that was given by a person or agency responsible with administering the law, such as a police officer. So a police officer can misapply the law in terms of giving you a citation or arresting you, and then later on that's considered as a mistake of law because the police officer is an authority that you respected, but you find out that actually they didn't apply the law accordingly. Usually appeals courts fix those issues. A person committed an act contrary to a law that's yet to be published. So it obviously the law was not made available to anyone, and that then when the law is published, it can't go retroactive because of the fact that that would violate um, the Constitution and commit what we call an after-the-fact law, or as we use the Latin term, ex post facto, or after the fact. These common elements are contained within that I just shared, North Dakota statute, mistake of law, which states that a person's good faith or belief that conduct doesn't constitute a crime is an affirmative defense if they acted in a reasonable reliance upon a statement or contained in a statute, judicial decision, administrative order, or an official interpretation by a public servant responsible for administering the law. So here's an example here. And it kind of fits with what I was talking about earlier, and you'll see if you didn't come in earlier when I was talking about this. Paul had a suspended license, and he wanted to drive his ATVs to go to work. Paul's mother called the local sheriff and asked a sheriff's deputy if Paul could operate the ATV even though his license was suspended. And he was told, yes, you could operate your ATV as long as you followed the laws. So one day while Paul was driving the ATV on his way to work, he was stopped for speeding his ATV and cited for operating with a suspended license. Well, Paul was convicted of operating while suspended, and the trial court didn't permit the jury to consider a mistake of law defense when rendering a decision. Paul appealed his decision, and it was overturned because the appellate court said that the trial court should have allowed the jury to deal with mistake, an error, and mistake of law should have been a permitted defense. And so what they did was they said, we're not going to even give them a chance for the trier of fact to even consider that evidence that was told to him by the police officer, and that they relied upon it. So so anyway, the appellate court judges said that the trial court made a mistake of law and should have been permitted as his defense. So in this case, Paul only drove his ATV and suspended license because he had received some bad advice. Now, I think one of the burdens would be proving that the officer actually told him that, and I don't know what evidence that his lawyer had. He probably had something that did it. Maybe even the officer was ready to provide that evidence and information. But the point of the matter is that he relied upon the police officer who was wrong, and so therefore he should not have been found guilty of operating his ATV, not his car, but his ATV. All right. So let's conclude by talking about self-defense. Self-defense is an affirmative defense that is all across the country, and it is basically saying that, yes, I did the offense, but the burden of proof, like other affirmative actions, is that the defendant must prove that they were justified in their actions and that their actions were within the law. An unlawful interference can include being punched, shoved, kicked, grabbed, strangled, or held against one's will. The amount of force used, it says, must be appropriate if it stops the unlawful interference but doesn't go beyond it. In other words, once the unlawful consequences stop, the force must also stop. So let's consider the situation that I represented a young man he was found guilty. He was charged with killing 2 people. Well, it was established very clearly that those individuals came to rob a crap game. Now, my client had a gun. They had a gun. And the evidence established clearly that these 2 guys announced that they were there to rob the place. And my client got a gun out, and he shot and killed both of them. And they were found, he was found not guilty by reason of self-defense, because that was my argument. Now, one of the bugs that we had in the case was that when he shot them, he went up and shot them in the back several times, and a lot of people thought that that was going to negate my defense. But what was important was the testimony of the coroner that established clearly that the individuals were killed consistent with my client facing them and they facing him with a gun, and that he got the shot off first, and that the shots that he fired in their backs were not the cause of death, and that they were in fact dead. So that didn't cancel out my self-defense. But anyway, I'm just showing you that the act must be. Now, let's say, for example, if a person hits somebody with something, and then they take out a gun and shoot them in terms of self-defense, probably it's not going to be justified, because the force necessary doesn't equal the force that was initiated. And that's the key thing. So let's look at this scenario here. It says Bob is walking on the sidewalk with his girlfriend, Margaret. And they're approached by this drunk man who threatens to punch Bob in the face. Bob attempts to avoid the conflict and tells the man, just come on, man, just let's keep walking, stop. And the man shoves Bob and draws his fist back to hit him. Bob reacts quicker, punches the man in the face as he falls on the ground. Bob then, upset because the man just tried to assault him, jumps on top of him and beat him until he becomes unconscious. Now, Margaret pulls Bob off the man, and they wait for the police. So the question that is applied is, was this adequate self-defense? I would say that the initial actions that Bob did would probably be consistent with self-defense, even if the person hit the ground, bumped his head, and died. But when he went beyond that and started jumping on top of the man and beating them until they were unconscious and he had to be pulled off. Now, that might be probably not murder. It would probably be involuntary manslaughter or voluntary manslaughter that would be the charge. So the question here is, was the force used by Bob to stop the intoxicated man legal and justified? And the answer would probably be yes. The answer would probably be yes. But when Bob got on top of the man and beat him until he's unconscious, did he go too far? The answer to that is yes as well. And look at what we say here in Illinois, which I am extremely familiar with because I had to use this many a times for the justifiable use of force. The Illinois statute states that a person is justified in the use of force against another when and to the extent that they reasonably believe that the conduct is necessary to defend themselves or another against such imminent or unlawful force. It says, however, he is justified in the use of force when it is intended to likely to cause death or great bodily harm only, get this only part after this, if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another, or the commission of a forcible felony. So therefore, in this instance, Bob would probably run into a problem under Illinois. Bob's force, it says here, initial force, was justified, but he committed great bodily harm when he continued on to beat the person. So self-defense, it must be demonstrated that the unlawful interference was imminent and that it was going to happen. Now, like the shooting I told you that took place, my client shot the guy because they had a gun also as well. If they had a knife or a dangerous weapon, Same thing. It doesn't have to be a gun used against a knife. It's still both classified as dangerous weapons and protecting his life and possibly the others as well. So most states in the U.S. don't require a person to retreat or before using self-defense. The concept is referred to as stand your ground. Illinois is not a stand your ground state, by the way, which doesn't require a person to retreat, presuming they are not engaged in unlawful activity and have the right to be where the action occurs. So the key thing is that stand your ground became famous to most of us because of the Trayvon Martin case that took place in Florida, which is clearly a stand your ground state. And so I still think they misapplied it in terms of how it was done. But the point of the matter is that what it is said is that individuals cannot assert a stand your ground claim if they're committing a crime when they are attacked. Also, people cannot claim self-defense in cases where they provoke the attack. Some states will not permit a self-defense in instances when the person attacked could have avoided using force, which is commonly referred to as a duty to retreat. So there are situations in our jurisdiction where you would have a duty to retreat, not if a person, for example, has a gun on you in that situation. So think about it. If you live in a stand your ground or duty to retreat state, we are not in a stand your ground state. Now, let me say this to you, that in terms of being a person in law enforcement, I had a young man to pull a gun on me, and I told the young man, told me to give him my wallet. I reached inside I said, can I reach inside my jacket? He said yes, and I was talking to him, and all while I was doing that, I had a shoulder holster on, and I pulled my weapon out and told him to drop his. And I was within my rights to empty my clip into him. But what had happened is that I had the young man to drop the gun, and he kicked it over to me. And when he kicked it over to me, I discovered it was a toy. But guess what? It would have been justifiable because I don't have to determine, is this a toy? I don't even have to ask, is it a toy? Because as you and I both know now, many toy weapons look like real weapons. And so the key thing is that it depends on the conditions. It was daylight. I was able to see the weapon, and it looked very real, but it was not. But the point of the matter is that if a person pulls a toy out, let's say, for example, a person raises a bat to hit a person, and they take out a gun and shoot them, is that probably going to be self-defense in a situation where they don't have the ability to escape or get away? Well, the answer is probably yes, but it would depend upon the totality of the circumstances. So you begin to understand the point of when we get into excessive force. So now we're going to talk about battered women syndrome. Now, the battered women syndrome is a defense that is presented in a situation where a person finds themselves under constant attack, and that with them being under attack by individuals, they have had enough of it, and they finally take steps to stop the individual, such as taking the life of that individual for the actions that they did. Now, the battered women syndrome, or BWS, has been used in cases to justify the killing of the abuser. And it is deemed to be a mental condition that's created by the actions of the person who had constantly beat them or abused them. But and so it's used in conjunction with saying that that's how they defended themselves from the abuse. Now, um, battered women syndrome has been claimed in instances where domestic abuse believes that they are a constant state of danger and not able to escape the environment, and they must resort to violence, including deadly force. Let's use this example, and I'm going to give you a real life example too as well. For example, and we're a little bit over time, but I'm going to finish up here. Diane has been physically abused and battered multiple times by her husband, Jim, over the past 10 years. Each time Jim's drunk, that's when she is battered the worst and has been knocked and choked unconscious. One night, Jim comes home drunk, and as they begin to argue over Jim's drinking problem, Jim begins to escalate, and Diane, fearfully that she'll be substantially battered again, shoots Jim. Diane is likely to argue in conjunction with BWS. Okay, and then you can look at a video here. Now, let me give you an example of a case where it was harder to prove, and I still believe I could have won this case. A young lady I knew, her husband was, how should I say, constantly violent with her. And in fact, I handled a real estate transaction for her, and I knew her since high school, and she married this guy, and she was the victim, according to her family and herself, of being beaten constantly by this guy. Well, one day, she got tired of it. Enough was enough. And when he beat her, and when he beat her, he went to sleep. When she then took out and found a gun and shot and killed him while he was asleep. The battered women syndrome wasn't handled properly by the lawyer, because I read the transcripts, and didn't do a good job of painting the history before a jury, not a judge, a jury. And she was found guilty of murder because it was deemed that she plotted and waited until after that. The argument could have been made very easily that she wasn't able to get to the weapon, and that her state of mind was still such that after that. Now, I don't remember how long it was after he had gone to sleep that she did it, but the point of the matter is that there was a possibility there. But the battered women syndrome is a defense that I've seen many cases that were won because the state of mind of that individual had been altered by the constant beatings that took place over periods of time. So, but it has to be raised as an affirmative defense. That is that, yes, I did it, but I did it under the influence of BWS. All right. So now let's talk about the castle doctrine. The castle doctrine means what it says. A home is considered your castle, your business, or your car. Permit a person within the dwelling to use deadly force to stop intrusion. And it doesn't require the person within the dwelling to retreat or to prove that the person did so with intent to cause great bodily harm. It's just that the mere actions that the individual does do that. So you don't put the burden on the person who is the potential victim. And it's normally required to use deadly force. Instead, what people do within the dwelling with the unlawful entry is they use deadly force to stop the intrusion. And the mere fact that the intrusion took place while in a protected area under the castle doctrine allows such an action. Now, it may be that the weapon is unregistered. They may be found guilty of that, but not of murder. And the castle doctrine works. Here's an example of a jurisdiction that has a castle doctrine, Kentucky. A person is presumed to have held a reasonable belief of imminent fear or great bodily harm to himself or another, and use defensive force that is intended to cause or likely great bodily harm to another if that person against whom the defensive action was used was in the process of unlawfully and forcibly entering the dwelling. So forcing themselves in, then they used a gun or a weapon and killed that individual, same with their vehicle and so forth. Or if that person had removed or was attempting to remove another, that is to take someone hostage from the dwelling residence and so forth. Now the person who uses this tactic, the users of defense, knew or had reason to believe that the unlawful action and forceful act was occurring at that time. So the key thing is that the reasonable fear of imminent death or great bodily harm to one or another within your presence is presumed. Therefore, the deadly force is justified to stop the intrusion. All right. Okay, and then it tells when it's not applied as well. So the final thing I want to talk about here is what's kind of something I talked about earlier, and that's use of force by police officers. I kind of hinted on that a little earlier when I talked about when that person attempted to rob me. But it says that law enforcement officers are held to a high standard, but a police officer is privileged to use reasonable force to effectuate the arrest of another person. Now, the force must be reasonable under the circumstances, not excessive, such as excessive beating and so forth. Sometimes the police use like hitting a suspect with a baton, taking him into custody will cause great bodily harm or either substantial harm. Same thing with tasing an individual. Just so the force is reasonable to make the arrest, the officer will not be charged with battery. But in contrast, similar force applied by a citizen would not have that same standard. So whenever a police officer uses force, there is oftentimes a review or a board or someone that looks over it, and that oversight committee determines that excessive force was not being used. But it says the deadly force is most highly scrutinized and should be, because death of another is, very serious. It's final. And so the use of force is rare. Well, depends. Depends on where you are and who you are. And police officers often show great restraint when making deadly force decisions, and then they provide some issues, some Second Amendment uses of deadly force, restraint, and self-defense. You can know about a few cases. Garner, I think, is one. But it says that when police officers use force, it's important that it's used lawfully and within the policy and procedure of the agency or department. If an officer makes an unlawful contact with somebody, such as stopping a person on a sidewalk and detaining them for no legal reason, any force that used in conjunction with the unlawful stop would be inappropriate. So it has to be for a legal reason. The use of force among police officers can also negatively affect community relations, as we already know. That has happened constantly in minority communities as well, and you know of cases all over the United States where we've had these kind of situations. And so here are some clips that you can watch. And so we conclude by reminding you that you can study the key terms, again, to prepare by using the flashcards. And of course, you can allow it, and so it's going to open it up. And so in this situation here, let me see if I can move this. I think I can. Here we go. For example, it says type of affirmative, and these are things that we've covered in the chapter, and I highly recommend going through these processes before you take your exam for each of those chapters. Excuse me, 4, 5, and 6. The type of affirmative defense, including use of force, self-defense, defense of others, and deadly force that justify the otherwise unlawful actions, is called justification defenses. Then you go to the next one. And then a test adopted by the Model Penal Code as is applied to determine if a person was sane at the time they committed a crime and they lack substantial capacity to either appreciate the rightfulness, wrongfulness. The name is right there in front of you. It is substantial capacity. A test applied to determine if a person was sane at the time they committed a crime. Remember, there's only 3 that's given. To be successful, defendants must demonstrate their mental illness prevented them from knowing the difference between right and wrong. We call that the right or wrong test or the Norton test. And then you can go through. And so applied to the intoxication defense, the level of proof necessary to successfully prove an intoxicated defense. Preponderance is often referred to as 51% certainty. Merely more than half certain is not beyond a reasonable doubt, but by preponderance of the evidence. And so those are just some of the things that you can do in terms of preparing for that. And then, as we do this a minute here, let's go down to the practice and deal with these fact patterns. Same thing. Take the time and go into them. Go into them. Let me see if I can move this now again. Okay. Put it back. Okay, here we go. Start the activity, and then you take these and you go over these fact patterns. Okay, and so then you pick the one. Jane has a white cat named Snowball that wears a pink collar and is outside each day. And one day the cat doesn't return. A few days later, looking for her cat, she finds Snowball and brings her home. However, later that same day, she realized that the pink collar was a tag with the name Princess on it. Jane contacts police, but she fears she will be arrested for theft. And that would probably be a mistake of fact. See if I'm right. Yep, she didn't intend to steal, and we talked about those kind of things. So you go through those kinds of scenarios. And then the last thing I'm going to do before I give you your the thing that I want to give to you and the final comments I want to make is, by all means, do this. Don't skip it. We tell you that every week. And you could go through these questions. You are defending a case where the defendant, Derek, is accused of killing his girlfriend during a schizophrenic episode and believed he had to kill his friend because he was the devil. You don't believe that Derek knew the difference between right and wrong at that moment. The rule of test most applicable would probably be the intoxication, the Durham, substantial capacity, or Norton. Which one do you think? Any ideas? It's the right and wrong test, the Norton rule. But you have to know this. In order to know this, you have to have listened to the lecture and what I said and what we covered in terms of it. So those are, there's those all the way through, and you want to go and do that. So now I want to go back to the classroom. And I want to say that the key phrase that I want is self-defense. That's it. Now, it's been a pleasure to teach you guys this class. As I said earlier, the quarter ends this Friday at 11:59 p.m. Central Standard Time. No exceptions unless you followed school policy and there was something, and I won't talk about that. But anyway, the point of the matter is that I hope you've learned a lot. Again, I say this whether it's criminal law, drugs and crime, with many of you are in both of those classes, or intro to corrections, or whatever class that I teach. APA is so important. And many of you lose points because I start talking about APA at the beginning, and I continue talking APA every week, and every week people still continue to lose points. Well, I'll tell you this week you won't lose points for APA because we don't get APA involved in the quiz, which is the final exam, and I don't require it for discussion posts. So therefore, for the last time you will have faced that issue is in week number 5. I do want to say this, is that if you have any questions about any of your assignments, I do have the assignments for week 4. I'm going through them, and they will be done. As a student one time says, I need to know how I'm doing from week 4 so I can know how well I need to do week 5. I say, don't do that, because first of all, number one, week 5's assignments were due actually Sunday. And now we're in week 6, and in this class, the assignment is a quiz. So your written assignments before that have nothing to do with your quiz. So any questions, feel free to reach out to me. My final grades for this class, as well as other classes, will be submitted by midnight on next Monday, which is the 17th, I believe it is. I got my calendar here. Yep, the 17th at midnight. So I will have had all the grades in for all of them. So if you have any questions between this time, you know how to reach out to me. I've said since the beginning what the policy is concerning that. Again, I thank you guys for attending, and I'm going to say good night at this time.